Docket 23. -038-05. That is people of the state of Michigan versus Avion Jackson. The parties, please introduce themselves for the record. Ms. Wilson.
Abigail Wilson for the people.
Ms. Wanchi.
Good morning, Your Honor. Melanie Wanchi from the Public Defender Office from State Jackson.
All right, and sir, you are Avion Jackson, is that correct?
Yes, correct.
All right, thank you. This is the time set for a preliminary examination. Ms. Wilson, how we proceed?
Thank you, Your Honor. And speaking with Ms. Wanji, it's come to our attention that there's some additional security footage that the defense is requesting. We have put in a request, but I believe I put it in Monday, so it's not here yet. So I believe the defense will be requesting a brief adjournment.
And is that a correct statement, Ms. Wanchi?
It is, Your Honor.
We'll adjourn for discovery purposes. I would indicate for the record that the defendant waived his right to a pre-limited in 21 days on January 11th. And so we will get a new date for
February 8th at 9.
February 8th at 9 a.m. All right, Mr. Jackson, please keep in contact with your attorney, Ms. Wanji. You'll get notice to appear on February 8th at 9 a.m. Okay, sir? Anything else for the record? 23-038-05. Ms. Wilson.
Nothing from the people.
Ms. Wanji.
Okay.
All right, thank you. You're all set.
Thank you.
Get you that paper. That's the only reason I asked if you have JIS this morning.
Is it back up?
I think for some people it is. Is it? Oh, do you schedule?
He
But
hands them out.
he hands them.
Oh, he can schedule. It's just,
For a while, nobody could do anything.
yeah.
Yeah. Well, on our end, we're having certificate problems, so we can't get into our version either.
Really?
Yeah.
Yeah, it's part of the outage problem.
Yeah. Your Honor, I'm just gonna pop out real quick. There was a
Sure.
witness that needed
Sure,
to.
Is it not, does that paper? Well, yeah, let me restart the printer.
There's somebody on like a microphone.
Let me guess, it finally printed.
Just one.
Okay.
Okay.
Chip to talk to them.
Yes, I did. Yes. Good question. Wait, see.
I forgot to write my comments to me. All right, so we're on the record in docket 23-03808. That is people of the state of Michigan versus Octavia Reed. Will the parties please introduce themselves to the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Wanji,
Good morning, Your Honor. May I have you on chief for Miss Reed?
and ma'am, you are Octavia Reed, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. One of my necessary witnesses had, he hit a deer with his car and needs to take his car to the shop, can't get a rental. I've told Ms. Wanji this ahead of time, and I believe she's in agreement for an adjournment today.
All right, Ms. Wanji.
That's correct, Your Honor. I discussed with my client and she agrees with that.
All right. I'm going to indicate for the record that on January 11th, Ms. Reed waived her right to did the 21-day waiver. I find that this is so we don't have to worry about the 21-day rule. Certainly you're in Michigan, so I will grant an adjournment for the preliminary examination. And we'll reset for
February 8th at 9.
February 8th at 9:30. All right, so we've scheduled this for February 8th at 9:30. Anything else for the record in 23-03808, Ms. Wilson?
Nothing from the people.
Ms. Mwanji?
Your Honor, yes, my client would like to ask permission to have it out of state. I know that one of the restrictions that you cannot have it out of state as long as this case is going.
And what is the purpose for driving out of state or going out of state?
I work as a exotic dancer and it's All-Star Weekend in February. And I was just trying to go to Indiana.
All right, if it is for work purposes, if you provide documentation to pretrial services for that you want to leave for work, I will grant permission to travel out of state for work purposes, okay?
Okay.
So I'm going to indicate the pretrial order is bond can be modified to leave state for work purposes with appropriate documentation, which would be something, give them something to indicate that you need to be there for work, something along that suffices for them so that this is for work purpose. All right, ma'am? Okay. Anything else for the record in 23-03808, Ms. Wilson?
Nothing from the people.
Ms. Wanji?
Nothing, Your Honor.
All right, Ms. Reed, we'll see you back here on February 8th.
Okay. Okay. I said something.
All right, so we're on the record in docket 02315. That is People of the State of Michigan versus Tierra Velasquez. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Good afternoon, or good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Ms. Velasquez, Your Honor.
All right. This is the time set for a preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. I do not have a necessary witness on this matter here today, but it's my understanding the defendant is also not here today. So I would leave it to Your Honor's discretion.
All right, Mr. Feigelson.
Your Honor, Ms. Velasquez is not here. I do know she was in the Ingham County Jail. I met with her a week ago. Make sure I get the date right. Actually, yeah, a week ago, the 19th. I know she was aware of being here today. I don't know where her whereabouts are. This is an older case. I don't know if the alleged victim of this case is going to reappear. I'd ask, given that this case be dismissed, they can always refile it if and when Mr. Cortez reavails himself to the people.
Well, the main problem here, and this is an armed robbery, is getting Ms. Velasquez here, as indicated. She was FTA on looks like the 18th. And I think she was in the Clinton County Jail at the time. And then she was returned to the Ingham County Jail where counsel indicated he saw her. She posted bond on the 20th. She was aware of today's proceeding. So if she'd shown up, the case probably is not going forward. But because she does fail to appear, and I don't think I've seen her since the beginning of this.
Your Honor, if it does make a difference to your decision, we have been in contact with the victim and he has stated he will not be participating.
He will not be participating.
I don't know if that changes what you're about to do.
Okay. But plaintiff unable to proceed.
Yep.
CB. So even if he was here, you would be unable to proceed,
Most likely.
assuming he came, and
Yeah.
we have some questions whether he'd come.
Yeah.
Okay, so I will grant the motion to dismiss. For Mr. Feigelson without prejudice. Since even if we went forward, there's some question as to whether the victim is going to appear. All right. So I am in possession of the Nolly Cross, and the case is dismissed without prejudice as indicated. Anything else for the record? 23-02315, Ms. Wilson.
Nothing from the people.
Anything else, Mr. Ferguson?
No, Your Honor.
All right, thank you. That's all for the record. That's fine.
When you may get a copy of the Nolly,
Yes,
thank you.
should be right there.
I believe we're ready
On this-
Smith.
On Ms. Smith. Okay. All right. All right, so we're on the record in docket 24-00050. That's People of the State of Michigan versus is it
Taylor's.
Taylor Smith. Taylor Smith. The parties please introduce themselves for the record. Ms. Wilson.
Abigail Wilson for the people.
Ms. Robinson.
Aaron Robinson, Assistant Public Defender for Mr. Smith.
And sir, you are Taylor Smith?
Yes, sir.
All right, thank you. This is the time set for preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. In speaking with defense counsel, there seems to be a question of whether or not Mr. Smith actually has a CPL, which obviously would be a pretty good defense to carrying a concealed weapon. He does not have the CPL physically in his possession. I guess he's moved and lost some documents. So I believe we're going to be requesting an adjournment so that he can go to the sheriff's office or wherever he needs to go to see if he can get a copy of that.
All right. Is Mr. Smith willing to waive his right to a prelim within 21 days today in order to see that he can get evidence concerning? the
He is, Your
CCW?
Honor.
Okay. May I inquire of your client if it's waiver
You may.
21 days? All right, Mr. Smith, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You, of course, are represented by attorney Aaron Robinson. She would be present to contest any charges or cross-examine any witness brought against you by the people. Do you understand that, sir?
Yes, sir.
Is it your intent today to waive your right to a prelim within 21 days so you can get documentation or evidence for your defense and for Ms. Robinson in order for her to zealously represent you?
Yes, sir.
All right, I'm gonna find the waiver, the 21-day, to be knowing, voluntarily, and actively made. And I'll adjourn the preliminary examination for negotiations to continue and some discovery purpose to
February 8th at 10.
February 8th at 10 a.m. Anything else for the record in docket 24-00050, Ms. Wilson,
Nothing from the people.
Ms. Robinson?
No, Your Honor, thank you.
All right, Mr. Smith, we'll see you here on February 8th at 10 a.m. Okay, sir? All right,
Your Honor, if I can step out. to close
Sure.
business. Thank you.
Mr. Abbott, you're here with Mr. York.
That's correct, Your Honor. We will be entering a plea.
All right, you can come up. I think we, after Ms. Wilson gets back, we can. Mr. Austin, you're here on Mr. Ash and Mr. Johnson.
That is correct.
All right,
May I approach, Your Honor?
you may. Thank you. Mr. York, you can have a seat until we get a assistant prosecutor. He's just checking on witnesses. All right, so we're on the record in docket 19-03293. That is People of the State of Michigan versus Gunnar York. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Abbott.
Good morning, Your Honor. John Abbott for Gunnar York. He's standing to my right.
And you are Gunnar York, sir?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe this is going to be a plea to an added count of use of, I believe, methamphetamine, which is 333.74 heroin. Oh, I apologize.
Or it was on that day.
So I still think that's the 333.
It's definitely a 333, but methamphetamine seems to have its own. So I believe it's going to be 333.74042A.
It's a 1 year and or
1 year. $2,000 and mandatory AIDS and hepatitis testing if there's intravenous use.
And with a successful plea and sentence to to the added count 2, count 1 is to be dismissed.
Correct, Your Honor, and there is no objection to 7411 status if he is eligible.
All right, so Mr. Abbott, I'll restate that and you can indicate if that's what you're understanding. It's an added count 2 of use of heroin under 333.74042A. It's 1 year and or $2,000 and mandatory testing. With a successful plea and sentence, count 1 is to be dismissed and there's no objection to 7411 status if eligible. Is that correct?
That's correct, Your Honor, and we will be asking for 7411 status.
Okay. And Mr. York, that's also your understanding?
Yes.
All right. Mr. Abbott, may I inquire of your client of his advice of misdemeanor rights?
Yes, sir.
And you did give me a, all right, so Mr. York, you've signed an advice of rights indicating you understand the 12 items on this paper and you've signed them, is that correct?
Yes, sir.
All right, so I'm just going to cover the 3 main ones. You understand you have a right to trial by jury, you have a right to counsel, you of course are represented by Mr. Abbott, who is here to represent you, cross-examining witnesses, contesting any charges brought by the state of Michigan against you, and you have the right to choose to testify in your defense, but the people can't call you as a witness. Do you understand that? Is that a yes? Okay. All right. You understand that with a plea to this, that you'll give up the claim the plea was a result of any promises or threats that it was not your choice to plead guilty, other than what's been stated on the record, and you'd be giving up the right to appeal anything that happened at trial. Since you won't be having a trial today, you'll be pleading guilty instead. Is that your understanding, sir?
Yes, sir.
Is it your, I just gave you your jury trial rights. Is it your wish today to plead, well, I guess you are, plead guilty to the added count 2 offense?
Yes, sir.
Okay. I'm gonna have you raise your right hand. Do you solemnly swear or affirm tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
Okay, I'm gonna bring your attention back to October 26, 2018, at the offense location of 5100 South Waverly Road in the city of Lansing. Were you at the 5100 South Waverly Road in the city of Lansing on October 26, 2018?
Yes, sir.
Okay, and at that time, in count 2, did you use the controlled substance of heroin at that time on that date?
Yes, sir.
All right, and you knew it was heroin when you were using it?
Yes, sir.
Okay, thank you. Anything towards a factual basis, Ms. Wilson?
Nothing from the people. Your Honor.
Mr. Abbott?
Nothing. Thank you.
Okay. All right, I find the factual basis to be understanding, voluntarily, and accurately made, and will refer to probation. So you go one floor down to the 5th floor probation office. They're going to ask you a lot of questions or set up a time to ask you a lot of questions. Just be as candid as you possibly can with them. They'll develop a report for me, and then at sentencing, we'll see what options are available to us. All right, sir?
Yes, sir.
All right. We have a sentencing date of
March 22nd,
March 22nd at 9 o'clock,
9:30.
at 9:30. So we'll set a sentencing date for March 22nd at 9:30. And that's when we'll see what options are available after they do the report. Anything else for the record in docket 1903293, Ms. Wilson?
Nothing from the people.
Mr. Abbott?
Nothing from the defense.
All right, I'll see you on that March 22nd date, okay, sir?
Yes, sir.
All right, thank you.
Yeah.
We'll see you, Mr. Abbott. Bringing Mr. Johnson up. And then Ms. Schroeder, you're here on Mr. Shakur.
Yep, and yes, Your
We're
Honor,
just stepping out to chat about it.
All right.
yep, and he is here in the
Okay.
courtroom.
Yeah, let's see. 10 and let McDaniel go get.
All right.
Johnson.
Let me read that.
Back in the office.
Okay, sure.
I was looking at they know what they are, they're interested in. But you read that. That slide, they want it. And the most condemned part of file track is reading the instructions. And this thing that doesn't have to do is yeah, so no, I mean, you have to bring that out.
And see if the judge will make an adjustment.
Oh, good. Good.
No contest with judge, so. Judge will read something to her. And, yeah. It's for life. Has the same effect. I understand. No matter what we do today. Unless the judge says so. Well, what we're trying. Well. No, then it's out when, then do you want to have it? Well, I mean, it's up to you. Well, if I don't want you. Well, I don't, then it sounds to me like we have to. Let's go talk about it.
Jonathan's with-
Yes.
Yes. Okay. Yeah.
Oh,
Yeah,
yeah.
okay.
Yes, that's.
Oh, okay, gotcha.
Not the.
Right, yeah,
Confident,
right,
Sane.
yeah. Mhm. Yeah.
Sure.
Are you gonna be addressing laundry as well, or, okay. Oh, really? What's good then?
Just me. How many witnesses have
For Mr. Ash, 3,
exhibits?
yes.
You are gonna get grounded. Abigail, Abigail, Abigail.
I don't have either one of those
Thank you, Mr. Russ.
things.
This seems to be my hardest teaching to new prosecutors. Okay. Play the Marky Mark game. Oh, silencing fire?
Yeah.
Can they make these numbers smaller? Yes, I'm all happy with that. Just a moment.
Okay.
Or if we do this in the middle, you'll get it down
Yeah.
here and ask me about that.
Okay.
I will find a way. to-
Yeah.
We see coming tomorrow to assist.
Yeah, it's just with the show cause, yeah.
I think. Yeah, I figured Andrew was coming because he had me listen to that. The funny thing was, I can't 100% say who Paige is talking to because he's not on camera
Ah,
and he never ID. I'm assuming that's who she was talking to.
well,
I will make sure they let me know. So
Yeah.
that they can communicate with y'all. And they can call back if I get frustrated with my service. If there's good, I mean, if anything is a good reason. I'll shoot guys your power.
exactly.
Yeah. I mean, and. Plus, I don't know what the issue is.
Well,
I don't know.
no, I don't.
Yeah.
Your choice is
No
your
idea.
choice. I cannot
I
make
saw
you
that.
do it. All right.
No.
Yeah.
I have to play this game.
Yeah.
No.
Yeah, I can.
Okay. Yeah. Gotcha.
Yeah. I almost said, I almost tried to do that, but I was just gonna think about it.
Thanks. Johnson, yep.
All rise.
Seated. Right, so we're on the record in docket 24-00059. That's People of the State of Michigan versus Marcus Johnson. Will the parties please indicate their appearance for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Austin.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Johnson. He is present with me at council table.
And sir, you are Marcus Johnson, is that correct? All right, thank you. This is the time set for preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. It's my understanding that Mr. Johnson will be waiving up to circuit court with an offer on the table of an added count of possession of methamphetamine under 333.74032B1 and an offer to plead to the concealed weapon as well, and the balance of the complaint dismissed. And just for the record, I believe the waiver will be waiting up as charged with the understanding that that's the plea offer up at circuit.
And is that a fair and accurate statement, Mr. Austin, of the current offer, which is the plea to the possession and then the CCW?
That is correct, Your Honor, and the more serious charge would be dismissed upon Mr. Johnson's plea and sentence to those charges. That is my understanding of the offer. That is what I've conveyed to Mr. to Mr. Johnson. We will continue to further negotiate at circuit court. It's my understanding that he would intend to waive up to circuit court with that pending offer in place.
Thank you. May I inquire of your client of his waiver of the preliminary examination?
Yes, you may.
Mr. Johnson, it's my understanding it is your wish today to waive your right to a preliminary examination. A preliminary examination is a probable cause hearing, which people would have to prove by probable cause evidence that the crime has been committed and the identity of the person who committed that crime. You are represented by Mr. Austin today, Brian Austin, and he would contest any charges, cross-examine any witnesses brought against you in your defense at the preliminary examination. There is an offer on the table that's been indicated for the record. This would be bound over as charged, but negotiations would continue, and the offer is the one stated on the record. Is that your understanding today? And is it your wish to waive your right to a preliminary examination?
Yes, sir.
All right. I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I'll bind over as charged this offense, these two offenses. So this will go up to circuit court. Your time in district court is done. It'll go to circuit court, which is a trial court, where you will await your next date from Mr. Austin. Mr. Austin, it's usually a couple weeks. But you're getting it from your attorney, and I'll have you sign the bind over document to that effect. Should be a place for that one of the new ones. I should say new. It's not that new anymore, is it?
There is a place for me, yes.
All right, I will indicate that the examination was waived on today's date, which is the 25th. And sign the document. And Mr. Johnson, you should be all set. Thank you for your appearance today.
And-
Mr. Austin.
Yes, but may I address bond with court, Your
You
Honor?
may.
Yes, thank you, Your Honor. Mr. Johnson's bond is currently set in a matter and form in which he is not and would not be able to post. I would ask the court to consider granting him some type of relief on that, even consider personal recognizance release. Mr. Johnson tells me he is willing to be monitored with a GPS tether, if that would help the court address any safety concerns or any concerns about him appearing in court. As far as I can tell, Your Honor, his iChat does not reveal any prior Michigan convictions. He does have some matters pending. He does have a place that he will be residing locally upon release. I think that should be probably already on file with the court file. He has been participating in catch at the Ingham County Jail. He would continue to seek help through CMH upon his release. I would just ask the court to consider granting him some type of relief on his bond. Thank you.
Thank you, Ms. Wilson.
Thank you, Your Honor. I believe I didn't see any priors on Mr. Johnson's history as well. If he has a place to stay, then obviously we would request that we have that address to send notices to and everything. I don't know if he has any other holds on him, so I will leave it to your discretion.
All right. So the CCW is a
It
it's
is
a
It's a
knife.
knife, yes.
I would indicate for the record that the bond was initially set at 5,000 PR. It was amended by the magistrate to 10% based on mental health concerns. So I would reinstate the $5,000 PR bond with the understanding that that the defendant is to follow up and to keep in contact and do anything that mental health indicates that is necessary in the case. So I'll modify the bond. I don't have any priors in this on the case. Modify the bond to the original 5,000 PR with the understanding that D is to continue any counseling or orders by mental health, by community mental health, concerning what they suggest for treatment. And I do want them tethered. We want a GPS tether. And that GPS tether is the notification. There's no. I'll make sure I get the. All right, your time now is done in district court. You will be on GPS, which is required. You are PR bonded, and you're to continue your treatment with mental health as they see it. Anything else for the record in 24-00059, Ms. Wilson?
Not from the people, Your
Mr.
Honor.
Austin.
No, Your Honor, thank you.
All right, Mr. Johnson, you're all set. Thank you for your prayers.
Thank you, Your Honor.
So you're gonna get Mr. Esch? Yeah. And then are we ready to go on
I believe we
Shakur?
are, yes.
Okay, my contact. Okay.
So we'll bring up Mr. Ash on the way down, and we'll continue with Mr. Shakur. Yeah, you can come up. Ms. Schroeder. All right, so we're on the record in docket 23-03791. That's people, the state of Michigan versus Elijah Shakur. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Shakur, who is present and standing to my right.
And sir, you are Elijah Shakur, is that correct? All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that Mr. Shakur will be pleading no contest to an added count of domestic violence, second offense, and that is 750.813. And that is a 1 year and/or 1,000. And there's a Killebrew to no upfront jail as well.
1 year and/or 1,000. All right, I'll restate that for the record, Ms. Schroeder, and then you can indicate if you're in agreement with that. This would be a domestic second.
Correct.
Okay. So it'd be a domestic violence 2. And that would be an added count 2. Domestic violence second, 750/813. So 1 year and/or $2,000. There's a Killebrew agreement and no upfront jail. So of course, if the recommendation comes back that any jail would be recommended, and I followed it, Mr. Shakur would have the opportunity to withdraw his plea. Is that correct?
Yes, Your Honor, that is correct.
All right. With a successful plea and sentence, count 1, and the habitual notice is to be dismissed. Is that correct?
Correct, Your Honor.
Yes, Your Honor.
All right, Mr. Shakur, is that your understanding of the plea agreement? All right. Counsel may inquire of your client of his misdemeanor advice and rights.
Yes.
All right. Mr. Shakur, you have the following trial rights that you're giving up, and I will indicate that for the record. We'll walk through that. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses brought against you. You, of course, are represented by a public defender and attorney, Aaron Schroeder. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your pleas accepted, if your no contest plea is accepted, you'll give up the claim that the no contest plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'd be giving up any appeal rights from a trial since you'd be pleading no contest instead. Is it your intent today to plead no contest to the added count 2? Okay. And you're waiving all your trial rights along in that regard. Is that correct?
Yes.
Yes. Okay. All right. So we'll use the police report as a factual basis.
And the prosecutor, I have indicated to her, I've highlighted relevant portions, and I believe we are stipulating to those portions.
All right.
That is accurate, Your Honor.
And for the record, we have the Lansing Police Department police report. It's case number 23519122737. And I'll indicate that that's what we're using as a factual basis for the no contest plea. What is the purpose of the no contest plea?
Lack of memory due to intoxication.
All right, so I do have 139 South Hayford Avenue as the address on December 25th, 2023. which makes for the location and venue and date concerning this matter. It was recognized that Heather Shakur had advised that her and Elijah Shakur, which is the defendant, had been married and living together for the last 5 years. Mr. Elijah indicated that they made contact with LPD. And during the incident, it appears that Elijah punched Miss Heather Shakur while they were in the residence. So anything towards a factual basis, it does not appear that the punching was done in self-defense. Anything towards a factual basis, Ms. Wilson.
Just that the victim Heather Shakur found the touching offensive, Your Honor.
Yeah, there's nothing here that would indicate that it reads like an offensive touching.
Mhm.
I don't think she says that, but it reads like an offensive touching, a punch
Mhm.
or multiple punches. Ms. Schroeder. Anything towards the factual basis on the no contest plea?
I would note that there was an argument that between the two
Right.
of them that preceded.
Right,
that.
this stemmed from an initial argument. I do have that the defendant was previously convicted on or about April 1st, 2015 of violating 750.81 parents 3. And so this is a second offense deemed a 1-year misdemeanor. Is that a fair statement, Ms. Wilson?
It is, Your Honor.
Ms. Schroeder?
It is, Your
All right. With that understanding, I find that the factual basis on the no contest plea to be knowing voluntarily, well, then I find the factual basis to be accurate for our purposes. And we will refer to probation for their report to be sent to me. So go to the 5th floor. They're going to do a report on this. And then they'll provide me a report and we'll see what options are available to us on the sentencing date. The sentencing date will be,
Did you want to?
yeah, probably on the 3rd, let's do it.
March 21st.
So March 21st at 8:30. So you'll be sentenced on March 21st at 8:30. Stop by probation for the report to be done. Anything else for the record? 2303-791, Ms. Wilson.
I believe, Your Honor, the defense would like to address bond, and the victim is here in the courtroom and does have a comment on bond if the court is going to address that.
All
today.
right, so I'll wait for the motion and then I'll hear from the victim. Ms. Schroeder.
Thank you, Your Honor. I do understand that the way this was originally charged, it was started as a felony. We have resolved it today with a misdemeanor. Mr. Shakur has been, for all intents and purposes, homeless since the event on December 25th last year. So almost a month. He's been living in a hotel room. He has been living out of his own car. It's my understanding there have been absolutely no allegations regarding any attempt at contact with Mrs. Shakur. My understanding is that there is on both sides a desire to have contact, to try to work on some things, to see about what can be done to remedy or at least get on a better path with the marriage. They have been together for quite some time. I think even prior to their marriage, they were together. I think my understanding is that Mr. Shakur also has some significant health concerns. He has congestive heart failure. He has been in the hospital multiple times since this incident occurred. It's been a lot of stress on him, and also being homeless for all intents. I do realize that this is a big ask, but Mr. Shakur would like to go home. And I think Mrs. Shakur wants him home so that they can work on some things. He has indicated to me he wants to try to see about some counseling with them together to try to work, to try to figure out what they can do to get this back on the right track. And I would suggest that if the court, given the fact of what the part of the no contest plea on this, if the court were so inclined to consider allowing him to go home, is that maybe a switch out to a scram tether might be a more appropriate, because I do believe that might still be eligible for the indigent funding and may be a way to assure that the domestic piece is kept going forward. I do know that today has been a very difficult moment, and this whole case has been very difficult for Mr. Shakur, but he also recognizes it's been very difficult for his wife, and he wants to try to get things back where they're supposed to be. Thank you.
All right, is there a Heather Shakur here? All right, Ms. Shakur, you can stand up, and as long as I can hear you, you can make your statement concerning what you wanted to say in regard to modification of bond.
I want him to come back home. Everything, it just blew up into something big that shouldn't have been something big. And I mean, I want him to come home with the kids.
All right, here's my issue. This is the issue with the case is the prior history, as one could imagine that this is not just one domestic violence. I've got a previous history of assault by strangulation on April 1st. I have a felonious assault, and I have an aggravated stalking. So, so this is my plan. I'm not adverse to lifting a no contact order, but it's not going to be today. Okay. Mr. Shakur is going to have to go down to probation. They're going to have to do a report, and they're going to reach out to you, ma'am, and you're going to have to tell them exactly what you just said here. Okay. Then if you tell them that, and so this will be pre to March 21st. If probation contacts me and says that we recommend this, okay, pre-March 21st, and I'll check with them. We'll lift the no contact order, maybe put a GPS scram notification. I think that's a fair statement. I just want to make sure that's all done by probation before I do that, that's in writing, okay? It's on the record right now. But this is a little bit more, it's the prior history that bothers me, okay? This was an habitual fourth offense notice. So at this time, I'm not going to modify the bond, but I will seek to modify bond once probation gets a hold of me and a report's done. So it's important to go down probation and get this ball rolling, because the longer that they delay their report or to contacting me, the further time we have to wait. All right, so I'm going to indicate that bond is not modified today. However, may be modified after probation's report and statement by yourself to probation. Right. Anything else for the record in 23-03791, Ms. Wilson?
Nothing for the people, Your Honor.
Ms. Schroeder.
Nothing to the defense.
All right, Mr. Shakur, we will see you on the sentencing date of March 21st. Your bond may be modified previous to that date. Okay, sir? Thank you. I'll return the police report for the no contest plea.
Okay, thank you very much. Oh, thank you. It just says that prior record.
Yeah, that's
Really at the end of the day, and I've done the
just-
same to Miss Wilson.
yeah, it's hard. It's hard to, but we'll look at it and we'll review it.
Yeah, I sincerely believe that's what she said, which is things just got out of hand.
All right.
No, because this is but she has a schedule.
And then Mr. Ash. All right, so we're on the record in docket 23-03042. That is people of the state of Michigan versus Scott Weston Esch. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Austin.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Esch. He is present with me at council table.
And sir, you are Scott Esch, is that correct?
Sure.
All right, thank you. This is time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we will be proceeding with the exam today.
All right, are there any preliminary matters to come to the court's attention before we get started? Ms. Wilson.
Not from the people, Your Honor.
Mr. Austin.
Yes, Your Honor, my understanding is there's going to be multiple witnesses. If that's the case, Your Honor, I would ask the court to order sequestration.
I think that's a fair statement. Both counsel know their case better than I do. So if you see anybody in the courtroom during another witness's testimony, you can bring it to my attention and we'll make sure the witness is sequestered. I see one other witness and then two attorneys right now.
Nobody for this case, Your Honor.
Okay, nobody for this case. All right. All right. With that understanding, Ms. Wilson, are you ready to call your first witness?
I am, Your Honor. The people would call Tracy Scott.
Tracy Scott, Tracy's my witness.
Yes. And he's a twin, so make sure it's Tracy.
Right.
So it's Tracy Ash, Tracy
Tracy
Scott.
Ash, wow, yeah. If you want to come through here.
All right. Are you Tracy Ash?
Yes.
All right, you can come up here.
Yes, sir.
Stand right in front of me and please state and spell your first name and last name for the record.
Tracy Neil Ash,
Spell them both.
TRACEY, ESCH.
Raise your right hand, which is raised. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Amen.
All right, you can have a seat here. Please use the microphone for recording purposes. That's from my court recorder, and you can project to the back as best you can. Right, sir? Ms. Wilson, when you're ready.
Thank you, Your Honor. Mr. Esch, I'd like to bring your attention back to August 22nd of 2023. Did you have occasion to have the police come to your house that day?
Yes,
What was that in reference to?
fire
Okay, and what is the address that fire had occurred at?
6028 Ralph Road.
Is that in Lansing,
Yes,
Ingham County,
yes,
Michigan?
yes.
And what is that building?
My house.
Your house? And when you say your house, do you mean that you live there?
Yes, I do.
Do you live there full time?
Yes, I do.
Okay. What's the first thing you remember in regards to the fire?
Get out. There's a fire in the basement.
Okay, and where were you when this happened?
Sleeping in my room.
Okay, and where in the house is your room?
To the back.
All right, so I'm gonna have you speak up a little
To the
bit
back of the property.
and move towards the microphone. Okay, thank you.
So your room is, you said on the second floor,
First floor.
first floor to the back of the home?
Back of the home.
Okay, and do you recall around what time this was?
No, I don't.
No,
Late.
it was later in the day?
At night.
Okay, and when you say that you remember, get out, do you remember who was saying that?
My son,
And what's your son's name?
Scott Weston Nash.
Okay, and he's your son, so you
Yes.
know what he looks like.
Yes.
So do you see him here in the room today? Can you point him out and describe something he's wearing?
Jumpers.
Okay,
Yeah, I think so.
I would request that the record reflect identification for the prelim today.
All right, Mr. Austin, any objection?
Without objection.
All right, yeah, for preliminary examination purposes, the witness is identified the defendant.
Okay, so you woke up because you heard Scott saying, get up, correct?
Yes,
Okay, did you hear any smoke detectors going off?
not that I can remember.
Okay, do you have any recollection of why the smoke detectors might have not been going off?
Probably hasn't.
Okay,
He said it before they went off.
okay,
It didn't make it upstairs. Thank you.
all right, and after you woke up, what happened?
I went to find out what was going on and grabbed the fire extinguisher.
Okay, did you smell anything?
When I came out, yes,
Okay, what did you smell?
burning.
Burning? Did you see the fire?
No.
No, okay. Did you get any inclination of where the fire was?
Yes,
Where?
downstairs,
And what made you think that?
because he said it's.
Okay. Prior to going to sleep that day, do you remember what you were doing?
No.
No, okay. Do you remember when you went to sleep, did you observe any signs of a fire?
No.
Okay. What was Scott's mood like on August 22nd, 2023?
Normal.
Normal? Did you see him before you went to bed?
I don't remember.
Don't remember? Okay. Had Scott done anything leading up to August 22nd, or yeah, August 22nd that raised your concern at all?
Not about anything I should be worried about, except for prior police calls.
And on August 22nd, 2023, how would you characterize your relationship with Scott?
Trying.
Trying. And what made it a trying relationship?
Is alcohol and thinking process.
Okay. All right, I have nothing further for this witness, Your Honor.
Mr. Austin.
Thank you, Your Honor. Good morning.
Good morning.
Oh, you were talking about you had an inclination that the fire was downstairs, is that correct?
Yeah.
And when you say downstairs, do you mean like a basement?
Yes.
And was this your house?
Yes.
And Scott was living with you at the time, is that right?
Staying there, yes.
And anyone else in the house living there full time other than you and Scott?
My twin brother.
And what is your twin brother's name?
Stacy.
And does he have a separate bedroom on the first floor as well?
Upper second story.
Okay. So one floor above you?
Yes.
Okay. And you said you did not hear any smoke detectors signifying that there was smoke or a fire, is that right?
Yes.
Okay. But you do have smoke detectors in the house?
Yes, I do.
Okay. Do you know if they were working at the time? Were the batteries in them up to date?
I doubt. I probably wasn't up to date.
Okay. And have you ever heard them chirp before, indicating when you need to replace the batteries?
Yes.
Do you recall if you heard that chirping that night?
No.
Is that no, you did not, or no, you don't recall one way or the other whether you heard it?
No, I didn't hear any.
Okay. Do you have any cameras in the house?
Yes,
Do you have any cameras in the basement?
I had.
Okay. And are those like home security type
Yeah.
cameras?
Yeah, yes.
Okay. And did you have those same type of cameras in the basement on the night of the fire?
No. Around the house, but I've had times him moving my cameras because he don't want to see, especially by the fireplace, see what's going on.
But on the night of the fire, there were no working cameras in the basement?
I don't recall how, I'd have to look. I have had other stuff recorded for what's been going on in the house.
And I'm just asking you specifically about the night of the fire.
Right, yeah, oh, okay, yeah. Yes, sir.
And said you were asleep when you started hearing the get out, get out.
Yes,
You know approximately how long you had been in bed or asleep when you heard that?
maybe an hour or two.
And when you say this was at night, you know, are we talking sometime before midnight or after midnight?
Near midnight.
Okay. And once you were alerted by hearing the get out, did you see your twin brother at all after that?
He came down about the same, well, after, I think I was the first one to be alerted to it.
Okay. And did you call and notify the fire department about the fire at that point?
I don't know if I did that or if he did.
When you say he, who are you referring to?
Scott or Stacy.
Okay. You have any fire extinguishers in the house?
Yes.
Okay.
Two. Oh, one.
One at the time?
One in the garage and one inside the house, yeah.
Did you see your brother take a fire extinguisher in an attempt to extinguish the fire?
I did because I was a firefighter in the Navy, so.
Okay. Were you successful in getting it extinguished?
Till the smoke got to my breathing because I had no breathing apparatus.
At some point, did the fire department arrive?
Yes.
Was the fire extinguished and out by the time they had arrived?
No, it was just temporarily muted, succumbed, but started back up
And when the fire department arrived, were you still inside the house or were you outside the house?
outside the house.
Thank you, sir. I have no further questions.
Redirect, Ms. Wilson.
Nothing from the people, Your Honor.
Based on, I'm gonna have a couple of questions because I might have missed, and then I'll let counsel ask questions after me. Where was your son staying? So where was Scott Esch staying in the house? Where was he staying at the house?
It was a basement.
He was in the basement,
That's where it's video games and stuff.
and that's where you traditionally stayed?
Yeah.
Okay. And when you indicated that you placed the fire extinguisher on, where were you? Where was that at? When you were putting out, using the fire extinguisher to put out any type of fire at the
Oh,
time?
it was directed to the stored bureau underneath, in between the two desktops or two